On May 2, 2025, Michigan driver Ron Doyle Glenn was hit with 8 traffic-related charges, 5 civil infractions and 3 misdemeanors. That distinction mattered immediately. In Michigan, a civil infraction can often be handled by paying the fine or asking for a hearing. But misdemeanor charges are different. Those require a formal court appearance, even when the case stems from traffic offenses. Glenn was ordered to appear on June 6, 2025 for arraignment on the misdemeanor counts and for a hearing on the civil violations. He didn't show. The civil matters moved forward with default judgments, exactly as Michigan law allows. But the criminal side couldn't be wrapped up that way, because courts can't simply default someone on a criminal charge. A show cause hearing had to be set for August 19, 2025 under Michigan Court Rule 6.615. A show cause hearing is the court's way of demanding answers. After someone misses a required appearance or disobeys a court order, they must come in, explain what happened, and justify why they should not face contempt or added consequences. Then the pressure grew. On May 21, 2025, Glenn picked up 4 more traffic charges, 1 civil infraction and 3 more misdemeanors, including driving with a suspended license. He was scheduled for arraignment on those misdemeanor counts on July 3, 2025, and once again failed to appear. That triggered another show cause hearing for July 28, 2025. He also missed the July 7, 2025 hearing on the related civil infraction, which led to yet another default judgment. By the time July 28 arrived, the court wasn't looking at one missed obligation. It was looking at a pattern. And when Judge Shaw Perkins took the bench in Detroit's virtual 36th District Court that day, the situation was already primed to go sideways.
Are you driving, sir? Mr. Glenn, Rondell Glenn?
Yeah, man, I'm sitting out in the sun, buddy. I'm trying to grab me something to eat.
All right, don't drive in court.
I'm not going to be driving, buddy, when I'm in court, all right? Just call me.
No, listen, I'm not your buddy, okay? First of all, but at the end of the day, if you're driving right now, you're not supposed to be driving, okay?
Okay, but how long am I going to be sitting here? I haven't spoke to no defense attorney.
I don't know how long you're going to be sitting there. You're waiting. If you came on time, you would have heard me. I said I'm going to try to get you out as fast as I can.
It's all good, man. Listen, it's all good.
Listen, don't cut me off. Are you driving your car right now?
I'm going to park my car, but, man, I can't be sitting out in the sun. You know what I'm saying?
I'm putting you out of the room.
Put me out of the room?
Yes, for driving in court. All right? Come back when you get in a safe location.
Attorney Gaten Robinson, on behalf of Mr. Rondell Glenn. Mr. Glenn, please state your name for the record.
Mr. Rondoyle Glenn.
Your Honor, I don't know how many tickets that was you just read off. I only have 3 on my docket.
Yeah, Mr. Glenn doesn't have any respect for the court. I see he's exhibited disrespect for the court, and he's
wait a minute, hold on, wait a minute. What you talking about?
You wait a minute. You wait a minute.
I'm going to the judicial tender commission.
You wait a minute.
I don't want you to remove yourself from my case, bro.
Listen,
I'm 58 years old.
That's the disrespect.
I don't know what it is about me and you, bro.
That's the disrespect.
Mr. Glenn, can you please be quiet for one? Mr. Glenn, as the attorney who's trying to help you, can you please be quiet for a moment? The first issue that you have is you should not be driving on Zoom. Park the car, please. You cannot drive on Zoom. This is the definition of distracted driving.
He should not be driving at all. He's already indicated to the court that he's driving when he was driving while in court. I asked Mr. Glenn that if he's driving, he said he's driving to go in and get something to eat, I believe. So now
Mr. Glenn wasn't driving. Somebody was driving for me. I'm with somebody. What do you mean? What do you mean, man? I'm 58 years old, bro. Look.
Mr. Glenn, I'm trying to help you. Can you please just wait a minute?
All these tickets from 20 years ago when it's only 3. You know what I'm saying?
Sir, stop. Mr. Glenn, stop so I can help you. I'm trying my very best to help you. You got a chip on your shoulder, but it's not. Sir, give me a minute. I'm gonna try to take you in a breakout room and talk to you before you make your circumstance worse. Just be quiet until you get there, please.
Yeah. Okay.
Thank
Mr.
you.
Glenn, Mr. Glenn, after you finish talking to him, I'm gonna give him a pre-trial date for tomorrow. Mr. Glenn has to come into court in person.
Fine. I'm going to the Judicial Tender Commission because you're very impartial. You're not about to try to embarrass me in court like
Mr.
that, man.
Glenn, stop.
Reading out all
Mr.
those things
Glenn,
when we only got 3.
just ask you to be
Listen,
quiet so I can help you.
I'm going to file a complaint
That's
today.
fine. You can do whatever you want, but
You're not about to try to
do you want
embarrass
my
me
help,
like that
yes
and
or
be
no?
disrespectful to me and think I'm going to sit up and take that.
Mr.
What's wrong
Glenn,
with him? Man, you
Mr.
tripping.
Glenn,
And they come to
Your
court
Honor,
properly
can I please?
dressed. Don't come to court in a sleeveless shirt. Come to court properly dressed.
Your Honor, can I please have a moment to talk to Mr. Glenn? I muted you because you're not making it better. Just be quiet.
It doesn't matter what you say to him. He's gonna take an anger management class too.
Your Honor, I'm gonna move Mr. Glenn to another breakout room.
Very good.
He's the Motorola device.
Yes. Move past the matter. Tell them to come to court properly dressed, Ms. Gates.
Mr. Glenn, you should have a prompt to come to go to breakout room 5. Go to breakout room 5. Look at your device, Mr. Glenn. You should have a prompt on your screen to go to breakout room 5. Just click OK. All right, Mr. Glenn, I'm gonna send you a different prompt. Just when you see the room number pop up, please just click OK. You're going to room 8.
All right, let's pass.
Just click OK.
Ms. Gaten Robinson, are you still dealing with Mr. Glenn?
Your Honor, Mr. Glenn was not the easiest to try to talk to or get to reason with. He has indicated to me, is he still in the breakout room? He told me he was coming down to the court today. He doesn't understand why he has to come tomorrow, so he's coming down to talk to the chief judge today, which I told him that is absolutely his right. He could. He felt like you were picking on him by calling out his older tickets. I explained to him that that is your process and the process of many judges down there, that when people have outstanding matters, if they are on your docket, you will pull all of their matters in an attempt to be efficient. And you've done that with multiple clients of mine this morning to try to reassure him that that was not you picking on him. He didn't understand why you were bringing up old stuff. So I explained to him that that's you trying to be efficient because he had multiple tickets in front of the court outside of the 3 that were on the docket.
After that tense exchange, Glenn's attorney, Phillies Gay and Robinson, explained what had set him off. He believed the judge was unfairly dragging old matters into the conversation when he thought only 3 charges were at issue. But from the court's perspective, something else was happening. Judge Perkins was trying to resolve every still pending matter in one sweep. That approach is known as judicial economy, the court's effort to use time and resources efficiently, avoid duplicate proceedings, and move cases forward without unnecessary repetition. In Glenn's case, that mattered because another show cause hearing was already sitting on the calendar for the following month. Rather than forcing everyone back into court to repeat the same process later, the judge tried to address all open matters in a single hearing. To someone unfamiliar with how courts operate, that can feel personal. Inside the system, it is often the opposite, an attempt to streamline the case before it grows even more complicated.
I indicated to him that he was supposed to be here tomorrow at 8:30 in the morning.
He's here.
I got his attention. He's aware that we're trying to pull him back into the breakout room. I'm about to send him a prompt. To the main session. I'm about to send him a prompt.
I'm trying to get him in the main. Stop close the rooms.
Okay.
Now, if he keeps it up, he'll find himself in contempt.
Your Honor, I'm trying to save him, but.
And I know it's probably going to be ordered as a transcript. So can y'all please talk at one time at a time?
Well, good luck. Good luck. You can get the video.
Sure.
All right. Let's go back on the record with Mr. Glenn. Mr. Glenn, let me say something to you, sir. Start your video, please.
I got it going. Get it straight now. Get it straight, bro. I simply wanted to come in and plead not guilty. But
Mr. Glenn, I asked you to stop talking to the judge like he's your friend or somebody on the street. You would not talk to another judge in a different jurisdiction like that. He's not your bro. He's Judge Perkins.
Now, let me stop. Let me stop right
I'm trying to help you, Mr. Glenn. You're making it worse.
Stop, Ms. Gaten Robinson, please. Mr. Glenn, let's get this understanding. First of all, I'm not your bro, okay? Yeah, I'm the judge, Mr. Perkins, but I'm not your bro, okay? Second,
I know you're not. Yeah.
No, I didn't ask you to speak. Don't talk while I'm talking. Secondly, if you continue to act out like you've been doing, I'm gonna have no choice but to hold you in contempt of court, okay? And I don't want to do that. I'm trying to exercise the utmost restraint with you.
At this point, Judge Perkins drew a clear line. He warned Glenn that calling him bro and repeatedly talking over the court was pushing him toward contempt. And that warning carried real weight. Under Section 600.170, one of the Michigan compiled laws, a judge can punish conduct that is disorderly, insolent, or openly contemptuous when it disrupts proceedings or weakens the respect owed to the court's authority. That is why this moment was more serious than it may have sounded. Using casual, street-level language toward the judge can be seen as a deliberate show of disrespect. Constant interruptions only make it worse because they interfere with the proceeding itself. In other words, Glenn wasn't just sounding argumentative. He was inching dangerously close to a sanction that could make his situation far worse.
Now, third, I called those cases into the record to be as a matter of judicial economy. I don't know when you got those tickets. I don't care when you got those tickets. I try to do that for the benefit of you so you don't have to keep coming back to court multiple times and you don't have these warrants sitting out here on you, okay? That's why I called those cases into the record. That's my choice to do that, and I called the cases into the record for the court and for your benefit so you don't have to keep coming back to court, okay? So,
yeah, I appreciate that.
I'm gonna let you speak. Let me finish. You're gonna come into court in person tomorrow at 8:30. I want you properly dressed. You can say what you want to do what you want to say. If you don't appear, then a lot of people don't show up. That's what the court has to say. Now, you want to talk? Go ahead and speak.
Next, Judge Perkins made another point that might seem minor on the surface, but matters deeply in court: appearance. He instructed Glenn to come in the next morning properly dressed. Under the 36th District Court's dress code, casual business attire is preferred. Shorts, cutoffs, sleeveless shirts, certain hats, and other clothing considered inappropriate for a courtroom or professional setting are prohibited. That kind of rule is not unusual, and courts have generally upheld it. Judges are allowed to enforce reasonable, neutral dress standards tied to dignity, order, and fairness. In a 2009 federal case from the Eastern District of New York, the court held that an attorney did not have a First or 14th Amendment right to wear jeans and a baseball cap in the courtroom. The broader principle is simple. A courtroom is not treated like an open public forum for personal expression in the same way a sidewalk or park might be. Judges are expected to protect the integrity of the process, and dress codes are one way they do it. So when Perkins told Glenn to show up looking appropriate, that was not personal. It was part of the court's authority to control the atmosphere and seriousness of the proceeding.
Okay. So I'm sorry about calling you bro. Okay. But I didn't think that you would get impartial and start, you were supposed to be here early. I'm 58 years old. Okay. So I'm kind of tech challenged, but I called down and I got in. Okay. I was late, but I got in, but it's just the way you was talking to me, that had me like, damn, I don't really want to go in front of this guy here, man. Plus I know Todd. So that's another reason why. Okay. So I was just asking if you could just recruit yourself. Then I found out some other stuff that's something, that's going on. Some news is going on right now. I don't want to be a part of that. I just want to go to another courtroom. If we could do it like that, then we good. Then I don't have to go down to the Judicial Commission, file a 3-page report. You know what I'm saying? Just recruit me from your courtroom. That's all I'm asking you.
So, Mr. Glenn,
on the grounds of, maybe not because I don't think you're impartial, but
let me finish. Let him go ahead and finish.
Okay. maybe not because I felt you were being impartial, but let's not say that. But I do know Todd personally. Been knowing Todd for a long time. So that's another issue. Not the other issue about what's going on with you now, but I'm just asking the court, please, just recruit yourself or just send me to another judge, and I appreciate it.
All right, let me, I'm not gonna send you to another judge. I want you to come down tomorrow morning at 8:30. I accept your apology about the bro situation. I didn't hold you being late against you, because I did let you in the room. As long as I'm sitting here, I question why people are late. I understand now why you're late. You told me you're not as tech savvy as other people, and that was it. You also were driving in court. You admitted to that. You have a
no. So let's clear that up. Listen, I have a business.
It's cleared up in the court's eyes. It's cleared up in the court's eyes. It's all being recorded. It's on transcript. You admitted to that. Okay. So
you can say whatever you want.
I let you speak. And I'm speaking. I said, do not interrupt the court. All right. So this is it. We're not gonna keep going back and forth. I'm gonna let you go about your day, but come down tomorrow morning in person. And you can go to the Judicial Commission. That is your full right. You can go to the chief judge, but I'm not going to sit here and have you yelling at my staff or anything, okay?
After addressing Glenn's behavior, Judge Perkins made the next step unmistakably clear. He had to appear in person the following morning. There is no bright-line Michigan rule that simply says a person may never drive during a virtual hearing. But the rules governing video proceedings give judges discretion to decide when a case is not suitable for remote handling. They are supposed to consider whether video participation preserves dignity, decorum, fairness, and the overall effectiveness of the hearing. That was the turning point here. From the judge's perspective, Glenn's decision to participate while driving showed exactly why this proceeding no longer belonged on a screen. The court concluded that the matter needed the structure and seriousness of an in-person appearance. His attorney also stepped in to protect an important right. Because Glenn was facing misdemeanor charges, he had the right to counsel. He could retain his own lawyer or, if eligible, request appointed counsel the next day. In other words, even as the hearing unraveled, the legal system was still putting procedural safeguards in front of him. The problem was whether he would take them.
Your Honor,
listen, I'm not
Mr. Glenn, please give me one moment. Please, I've been begging you since the beginning of our interaction. I'm trying to help you. Just be quiet.
Right. I should have brought my boy Blake in here. I wouldn't have all this.
Okay, so one moment, Your Honor. I explained to Mr. Glenn that he does have to be at court tomorrow morning at 8:30. I did also indicate to him that it's his absolute right to retain an attorney. If he is not able to retain an attorney, then he can ask for an appointed attorney tomorrow. Because he is here for misdemeanor matters, he is entitled to counsel. If he wants to pay his own counsel or ask for counsel tomorrow, that is his right. But I'm making it clear that Mr. Glenn is aware of his right to have counsel tomorrow at court.
All right.
If Mr. Glenn come to court, he's coming with all the news coverage. Okay, so we just want to make sure everything is good.
We'll see you in the morning at 8:30. Make sure you look good for the news.
I want another judge,
on.
and I make it with another attorney.
One at a time, court reporter.
Put your good suit on. We don't care about you coming with the media. Look good for the media. Put your suit on.
I don't want you. You know what? As a matter of fact, you're on ineffective counsel too. So I'm good. We're gonna reschedule that.
Have a wonderful day, sir.
Let's handle it like this.
Stop it, Miss.
Have a wonderful day.
Don't say any more, Miss Robinson, please. Mr. Glenn, that's it. Okay. I'll let you make your record. Come on down tomorrow morning, all right? You're muted. You're muted now. Unmute him, please. Unmute yourself. Unmute yourself. All right.
Let me do what I gotta do. Okay. Yeah. All right. Bye-bye.
Peace of luck to you, sir.
Yep. Take care.
He didn't. Glenn failed to appear for the rescheduled in-person hearing the very next day, and the court issued a bench warrant for his arrest. As of the writing of this episode, he was still set for a show cause hearing on August 19, 2025. What makes this case so revealing is how sharply the law separates civil infractions from misdemeanor offenses, even when both come from traffic conduct. Civil violations can often be handled mechanically, with default judgments when someone does not show. Criminal charges are different. They require the defendant's personal accountability before the court, and Glenn's repeated non-appearances made that impossible to ignore. The hearing also exposed how much power courts have to preserve order. That authority can show up in several ways: contempt warnings, courtroom dress requirements, and a judge's decision to pull a matter out of virtual court and require an in-person appearance when remote participation starts undermining the process. At the same time, this case reveals a deeper tension inside the justice system. What a judge sees as efficiency, like consolidating related matters to avoid wasting court time, a defendant may experience as hostility or bias, especially if they do not understand the procedure. That gap matters. It is why both lawyers and judges have to explain the process clearly enough that efficiency does not destroy trust. But there is another truth this hearing makes impossible to miss. A defendant's own behavior can change the course of a case faster than almost anything else. Driving during a virtual hearing, interrupting the judge, taking a confrontational tone, and ignoring direct instructions did not just create a bad impression. Those choices escalated the stakes. In court, respect is not cosmetic. It can be the difference between a manageable problem and a much worse one. If there's another courtroom confrontation you want covered, drop it below. And if you found this breakdown useful, share it with someone who should see it.